It wasn't the first lie ever told before the United States Senate, and it certainly won't be the last. But what Attorney General Pam Bondi said before the members of the Senate Judiciary Committee this afternoon may very well go down as one of the most brazen, most shameless. The two-tiered system of justice is over. In fact, if Bondi's on-the-record testimony today served to prove anything out in public, anything at all, it is that a two-tiered system of justice has very much been operationalized, is the new reality in the United States of America right now. Just ask former FBI Director Jim Comey, whose recent federal indictment, initiated mere days after a public pressure campaign, was a frequent topic of inquiry this afternoon. Again and again and again, Bondi refused to answer questions on the matter, questions about Eric Siebert.
Hey guys, Mia Harper here. This is the moment the lie shattered. The moment the carefully constructed testimony of the nation's top law enforcement officer disintegrated under the cold, hard weight of evidence. The Attorney General of the United States, under oath before the United States Senate, looked the American people in the eye and told a story that was not just misleading, but a calculated point-by-point fabrication. And now it has all come crashing down. This isn't about a political spin or a difference of interpretation. This is about perjury. This is about a federal crime committed in the well of the Senate chamber. And in a stunning turn, the judicial system is not looking away. A federal judge has now heard the evidence, reviewed the testimony, and delivered a reaction so severe it echoes with the clang of a prison door being unlocked.
The night before James Comey's indictment, you had dinner with the President of the United States. Pretty intimate group.
Actually, there were a lot of people there that night. That's a great picture.
Was James Comey discussed at that dinner?
I love that picture. That's a great picture. And there were a lot of people there that night. I think the entire cabinet was there.
Did you discuss James Comey with the President of the United States? He was sitting just to your left.
Well, 2 seats down, yes. 2 seats down. And I am not going to discuss any conversations I've had or not have with the President of the United States.
Because the American public is entitled to know, Madam Attorney General.
The entire cabinet was at that dinner.
Took instructions.
Pam Bondi, Trump's hand-picked Attorney General, isn't just in political trouble. She is on the precipice of a federal indictment. The stage for this legal and political detonation was the Senate Judiciary Committee confirmation hearing. Bondi, a longtime Trump loyalist with a controversial past as Florida Attorney General, was being vetted for the highest law enforcement post in the land. The oath she took was unequivocal to tell the truth, the whole truth, and nothing but the truth. What followed was not truth, but a defensive fortress of denials built specifically around the most perilous part of her recent past, her active documented role in Donald Trump's efforts to overturn the 2020 election. Senators, armed with mounting evidence from ongoing investigations, pressed her on her involvement. Their questions were direct and lethal. Was she involved in the coordination of the fake elector schemes? Did she communicate directly with President Trump about pressuring state officials? Was she part of the pressure campaign targeting election workers in Georgia and Michigan? Bondi's answers were a masterclass in calculated evasion that crossed into outright falsehood under the solemn power of her oath. She constructed a narrative of detachment. She claimed limited knowledge. She painted her role as peripheral. She denied direct coordination. In essence, she presented herself as a bystander to the most consequential anti-democratic plot in modern American history. She looked the senators in the eye and said, in effect, I wasn't really part of it. But the paper trail did not corroborate her story. It convicted her. What emerged in the hearing, thanks to dogged investigative work by committee members, was a damning counter-narrative built on facts, not allegations, but documents. Senator Sheldon Whitehouse, in a methodical and devastating cross-examination, became the human embodiment of this evidence. He did not merely accuse, he presented. He held up email chains that showed Bondi's name on communications, pressuring Georgia officials to validate alternate slates of electors. He cited phone logs that placed her in direct contact with Trump during critical periods of the scheme. He laid out a timeline of coordination that placed her at the heart of the effort, not on its fringes. Confronted with this documentary evidence, Bondi's facade crumbled in real time. Her denials rang hollow against the printed proof. Her claims of ignorance seemed absurd in the face of her own digital fingerprints on the conspiracy. The hearing room atmosphere shifted from one of political theater to one of a live perjury trap closing. It was no longer a question of policy differences. It was a stark demonstration that the nominee had just sworn to a version of events that the record flatly contradicted. The committee wasn't just rejecting her nomination, it was witnessing a potential felony. The fallout from this explosive hearing was not confined to Capitol Hill. It landed on the docket of U.S. District Judge Tanya Chutkan, a jurist with a front row seat to the January 6th related cases and a reputation for nonsense rigor. Legal observers waited to see if the judiciary would treat this as a political dispute or a matter of criminal contempt for the rule of law. Judge Chutkan's reaction was seismic. In a court proceeding reviewing related matters, she addressed Bondi's testimony not as a political controversy, but as a potential obstruction of justice. She methodically dismantled Bondi's flimsy post hoc justifications that she merely used the term irregularities or had a different understanding of the schemes. The judge found these excuses not credible. In clear, unambiguous language, she signaled that the evidence presented to the Senate, if proven, constituted more than just misleading statements. It constituted knowing falsehoods made under oath, the very definition of perjury under 18 U.S.C. Par 1621. Judge Chutkan went further, discussing the mechanisms of accountability. She openly mused about contempt proceedings and the possibility of a criminal referral to the Justice Department for prosecution. Her words were a judicial roadmap to prison drawn in bold strokes. When a federal judge of Chutkan's stature speaks of perjury charges and prison time in relation to sworn congressional testimony, it is not an offhand comment. It is a 5-alarm fire in the legal world. She was in effect stating that the Attorney General had likely broken the law she is sworn to uphold, and that the path to holding her accountable was clear and open. This creates a constitutional and political crisis of unprecedented scale. The head of the Department of Justice is now herself the subject of a credible perjury investigation, all stemming from her efforts to conceal her role in an attempt to subvert democracy. The irony is so profound it borders on satire. The chief law enforcement officer is accused of lying to cover up a crime against the electoral process itself. Let's dissect the anatomy of the lie and why Judge Chutkan's reaction is so justified, the materiality of the falsehoods. Bondi wasn't lying about a trivial detail. She lied about the central disqualifying aspect of her recent conduct. The Senate's duty was to ascertain her fitness for an office requiring unimpeachable integrity and respect for democratic norms. By hiding her involvement in the fake elector scheme, she directly obstructed their constitutional duty. Her lies were material to the very purpose of the hearing. The evidence of knowledge perjury requires the speaker to know the statement is false. The emails, phone logs, and witness accounts presented by Senator Whitehouse create an irrefutable record of her active involvement. For Bondi to claim ignorance or non-involvement, therefore, was not a lapse of memory. It was a conscious choice to falsify the record. She knew the truth and chose to swear to a fiction, the pattern, and the motive. This was not a single off-the-cuff mistake. It was a series of coordinated denials on multiple key topics. The motive is transparent to secure confirmation by airbrushing a seditious conspiracy out of her resume and to protect both herself and Donald Trump from further legal exposure. The lie was a strategic tool for career preservation and political protection. The implications of this scandal radiate outwards, poisoning every facet of the Trump administration. The end of Drain the Swamp. Trump's core promise was to root out corruption. Instead, he elevated a figure in shed in election subversion and now credibly accused of lying to Congress to cover it up. Bondi isn't an example of a drain swamp. She is the swamp incarnate, a creature of loyalty over law, installed at its highest level, a weapon for the opposition. For Democrats, this is not just a scandal. It is a pristine, gift-wrapped narrative for the upcoming midterms. It allows them to campaign on a simple, powerful message. Their attorney general is a liar who tried to overthrow an election. Ours will uphold the law. Campaign ads will feature the damning Senate clips and Judge Chutkan's stern warnings. It crystallizes the argument about corruption and the rule of law in a single, unforgettable image: the hypocrisy of law and order. The Trump movement's constant drumbeat of law and order and punishing criminals collapses into absurd hypocrisy when its chief law enforcement officer is facing prison for lying to Congress. It exposes the philosophy as purely transactional. Law and order for you, impunity for us. The ultimate Trump dilemma. This forces Trump into a choice with no good outcome. Does he pardon Bondi? Such an act would be the most nakedly corrupt use of presidential power imaginable, shielding his own AG from prison for crimes committed to protect him, destroying any last pretense of an independent justice system. Or does he abandon her? This would reveal the hollow, disposable nature of his loyalty, chilling every other ally who might be thinking of taking a fall for him. He is trapped between looking like a corrupt autocrat or a disloyal coward. Beyond the immediate politics, Bondi's perjury is a keystone in the larger arch of the post-2020 cover-up. It demonstrates that the conspiracy did not end on January 6th. It evolved into a subsequent conspiracy to conceal the first one. The lying wasn't just to voters. It was now under oath to the United States Senate. This represents a dangerous escalation of the original lawlessness, moving from subverting democracy to systematically defiling the institutions designed to investigate that subversion. Judge Tanya Chutkin's reaction is therefore a watershed. It is the judiciary, the branch designed to be insulated from political winds, stepping in to affirm that some lines cannot be crossed. By naming perjury and plotting a path to prosecution, she is doing more than commenting on a case. She is reasserting a fundamental principle that testimony before Congress is sacred, that the truth matters, and that no one, not even the Attorney General, is privileged to lie their way into power or out of accountability. The final act of this drama is yet to be written. Will the Department of Justice, an institution now led by a potentially compromised figure, investigate its own boss? Will a special counsel be appointed? Will Congress pursue its own contempt charges? The avenues are fraught, but Judge Chutkin has lit the way. Pam Bondi did not merely have a bad hearing. She walked into the Senate, raised her hand, swore an oath, and then methodically perjured herself in a failed attempt to bury her role in an attack on American democracy. A federal judge has now certified that failure and pointed toward the consequences. The admission of the lie, forced by evidence, has been made. The judge has reacted. All that remains is the reckoning. The highest law enforcement officer in the land may soon need a lawyer of her own, a defense attorney for a federal perjury trial.